This is time set for a public hearing as to ADKT 533, in re amendment to the Supreme Court Rule 78.5. This pertains to the auditing of trust accounts. On behalf of the State Bar, this is at your request, Mr. Valerie, or Mr. Scott, whoever is. Yes, you want to stand behind, supportive now?
Chief Justice and Justices, thank you for your time. As President of the State Bar of Nevada, I'm here to argue for the support of ADKT 533. The State Bar had a task force look at the implementation of random trust accounts. I gave it a lot of study. We did a survey. We've had meetings with several law firms, about 34 in total. And this issue with regard to random trust accounts, we vetted with them. We discussed it with the Nevada Justice Association, and I've written a lot of articles in support of it. Currently there are 3,000 trust accounts in the state of Nevada with regard to through IALTA accounts, and those IALTA accounts have over 400 million, or should have 400 million in those accounts. And there's no question that attorneys have an obligation to their clients to properly account for the monies held in trust. And misappropriation, whether intentional or due to poor accounting practices, seriously erodes the public trust in lawyers and in our profession. And the State Bar has an obligation to ensure to the public that what they provide to an attorney is maintained in safekeeping. And the State Bar also has a duty to educate its bar on how to properly maintain trust accounts. So the central objective of the Random Trust Account Compliance Program is to ensure the books, records, and the accounts of an attorney's practice comply with the court's financial record-keeping rules, and to educate the bar, the lawyers, on how they should keep those accounting records. Additionally, statistics about the nature of client grievances is filed with the State Bar highlights the need for this program. The State Bar receives about 100 open grievances a year, 100 dealing with safekeeping of clients' property. Of the current 300 open matters currently before the Bar Council, 75% of those involve safekeeping of clients' money. And having served in the Client Security Fund for 20 years, I was able to see why there was a need for some sort of random audits, because the Client Security Fund, just in the last 5 years, has paid out, has approved $3.1 million with regard to claimants who come before the Client Security Fund because the lawyers have misappropriated or failed to have the trust funds in their account. Ultimately, this program is designed to increase not only public protection, but to educate the attorneys on how to properly maintain trust accounts. Like we do with respect to all our proposals, we do surveys. before we bring them to the court. You get an idea what the attorneys think of the proposal and their objections. What's really interesting is what they could agree with. 76% of the attorneys that responded to the survey said that they would be interested in guidelines or best practices in establishing and maintaining a trust account. And another 77 said they'd be interested in courses on trust accounting. Now, unfortunately, the CLE, if we did the CLE, we'd be preaching to the people that comply with the rule, because those are the ones that would seek out the CLE. So it's deemed that we need to be educating the attorneys more on a one-to-one basis. And that's what the random trust account audit program would do, is we would go in and at no cost to the attorney. It would be borne by the state bar. But we would go in to look at their trust accounting, and if they needed education with regard to how to properly do it, and there's only issues, small issues, we would assist them and educate them with regard to how they should be maintaining their trust accounts. We will do exit surveys with regard to these trust accounts. They will be done. We will write reports and give them to the attorney so they're fully informed how they can improve their accounting methods and how they can comply with the rule and how they should comply with the rule. Currently, the State Bar of Nevada Office of Bar Counsel has the authority to review financial records of attorneys pursuant to disciplinary investigations. And Supreme Court Rule 78.5 also gives authority to the State Bar to inspect financial records of client trust accounts held in accordance with Supreme Court Rule 217. RADKT it seeks clarification that we can and go and do random trust accounts. The surveys that we did with regard to the attorneys, we sent them out to 8,900, got about 1,200 responses. And their primary complaints was disruption of practice. They were concerned about the cost, whether it was going to cost them money, and confidentiality. So I'll touch the first one with regard to disruption of practice. There should be minimal disruption of practice, because if the attorneys are doing what they should be doing with regard to the trust account, then they merely convey it to the bar office, where trained people in accounting principles will review their records, and it should be done by just transmitting by the internet. With regard to the expenses, the attorneys are being audited will not have to pay any money for the audit process whatsoever. Confidentiality. That seemed to be a big issue with the large law firms. And we met with them and we told them that, and they were happy with the response, that this process with respect to, it will be deemed confidential with regard to reviewing their clients' information, okay? As confidential as any matter can be, considering if we find violations with regard to the trust account, that would have to be turned over to the Bar Council for handling. So I think that to address the concerns of various people in the survey, the Bar has submitted Exhibit D to the petition, and it's the policies and procedures and how we see how the program would evolve. And the first one is random selection. It would be totally random. But if an attorney with regard to a law firm get selected, the entire law firm's trust accounts in the state of Nevada would be reviewed. The audit attorney, the random selection, we would give them 2 weeks prior notice that we're going to do it. If they have legitimate reasons why it should be continued, we would review their request. We would give it consideration. The compliance, the audit attorney would be provided the full extent of the audit report for their review. And I think it's important to note that any minor deficiencies are found, we would use those as educational to teach them how to better keep their trust accounts. However, if there's major deficiencies, and we see a pattern, those will be turned over to the bar council. But the purpose of the random trust account is educational, primarily, and secondarily, it's deterrence. We believe that there's 12 states that have adopted random trust account audits. I was just in the state of Washington last Thursday meeting with them, and basically they have found a substantial decrease with regard to grievances because of the random audits. What it does is it requires the attorneys who are practicing and have trust accounts to take care to do it properly. And when they do it properly, then they have less complaints to the bar. There's one point that when we met with the large law firms and other law firms, they said, and also the small law firms, there are some exceptions. If an attorney doesn't hold clients' trust funds, they can tell us that they don't hold trust funds, and therefore we would not do an audit of their trust accounts. Or if they already have audited financials of their trust account, which most large law firms have, that would comply with the rule as well. So we're attempting, with regard to the random trust account audit concept, to educate the lawyers, give faith to the public in our profession, and that the funds that are held by lawyers are maintained safekeeping, and to avoid the problems that we've had in the past with regard to lawyers misappropriating funds that are in the trust account. That's our intent, our purpose, and that was the purpose of the trust fund, the task force, and then the recommendation to our Board of Governors, and our Board of Governors has approved it to submit a ADKT, and we're here today to fully support, in all respects, the random trust audits to be implemented in the state of Nevada, which wouldn't occur until 2019, because we'd have to retain, either by contract or hire people competent to be able to do the trust audit program.
Thank you. Mr. Laverty, before you sit down, first things first, I was remiss. Two of my colleagues are not here presently, Justice Gibbons and Justice Perigary. They will participate in any decisions made by this court in that decision-making process. As to your remarks, we appreciate them. Your moving papers that you had submitted with your request tended to indicate that you were looking at possibly about 60 audits a year.
Yes, Your Honor. That's our anticipated goal, is 60 audits a year. But with regard to if a firm has audited trust accounts, okay, and they provide it to us, that number could increase, actually, because a lot of people, they could comply. We could select a law firm, a major law firm. Everyone in that law firm, if they have an audited trust accounts, that would be able to do 60 others.
As to you indicated there were 12 jurisdictions that presently are doing audits.
Yes.
5 years, over 5 years, less than 5 years, any idea of what they...
I'm sorry.
in terms of period of time that they've been involved in doing these random audits?
Yes.
Over 5 years, less than 5 years, or?
You know, they've all been doing it for several years, more than 5 years. I have a list of the.
It's Exhibit B to your petition, I think, and it shows 4 of them are not enforcing it.
Yeah, there's, the rule's not being enforced, you're right. Arizona, they have random, the rule's not currently enforced. Connecticut, they do 250. Delaware, they do 60 a year. Hawaii, the rule is not enforced. Iowa, the rule is not enforced. Kansas, 24. Nebraska, the rule is not enforced. New Hampshire, statistics not available. New Jersey, 730 a year. North Carolina, 60 a year. Vermont, 10 to 20. And Washington, 80 to 100.
And Madam Clerk, in our packets we have a letter of opposition from Attorney Andrew Craner. Do we have any other opposition that you're aware of? Colleagues, do you have any additional questions?
President Leverty, what I worry about is that the large law firms are going to have nothing to worry about, and every small law firm is going to have something to worry about. That if you do 60 audits, I assume that 55 of them will be small law firms. And what's to prevent that type of disparity? In other words, a large law firm, especially the national law firms, I'm sure they all have audited trust accounts, and so they'll have no worries. But small law firms could have a worry, such as theft by somebody that they have entrusted with their trust account, such as a legal assistant or a secretary. How do you answer that?
Well, Your Honor, I have an issue with regard to if a lawyer, whether small or large, has a problem with the trust accounts, they're not doing what the rule requires. And our whole purpose is to educate them to make sure that they don't have problems with their trust account. And we're going in to help and to assist these small practices. It's not large or small. It's to make sure that anyone's money is held in trust properly. And we're not focusing on the solo practitioners, the small practitioners. We are there to assist them. And wouldn't it be good to have those solo practitioners know what the guidelines are and how they should properly do their trust accounts? And I think that's the educational aspect. I looked at, California has guidelines and rules, and I happened to review those in preparation because that's what we intend to do, is develop guidelines and rules. And having met with some of the firms, criminal lawyers, it came to me, they said, well, we don't put any money in trust account because we have in our retainer agreement is fully earned. So there is no money that goes in. Well, then I talked to other law firms that do criminal law, and they said, now we put it into trust account and we take it out as we believe we earn it. Well, we need some rules so that everyone's playing under the same rules with regard to how those trust accounts should be done. So when I was speaking to the NJA, and I told them we're going to have this rule committee, this guideline committee, and they had concerns. And I said, I want you to participate in this committee, and so we can work out what works for the practitioner and what works to comply with the rules. And there is, it's not, the trust account seems like it's a simple concept. It's more complex because everyone looks at it a little bit differently, depending on their area of practice. And that's what we need, uniformity, so that everyone knows what the rules are.
Well, what are you going to do about the firms that have the non-refundable issues?
Well,
when I was on the disciplinary committee, we had issues like that, and luckily I brought forth some people from some large firms, Linosaurus, some other ones, and they were able to sustain that type of practice, where somebody would get $5,000 and that was theirs from the get-go, whether the case was filed or not.
Yeah, and I think that that's what we need to have rules on, so we all know, is it proper or is it not proper? I will tell you, having served on the Client Security Fund for a lot of years, and I've raised this, we had a lot of issues with regard to a lawyer who collected a non-refundable fee, and then he got disbarred or he got suspended. And so the issue was whether they were entitled to be reimbursed from the Client Security Fund. Okay, and the Client Security Fund paid those claims, okay, because they felt that he was unable to perform the services. But we need some rules. We need some guidelines. And how better to do it than to bring those people that are doing that area of practice, like the criminal aspect, and bring them in and say, how should this be handled statewide? So we're all doing it the same way.
Why are you exempting the people who have audited trust accounts? Why are they exempted? Why exempt them? Who knows who does it? I mean, what are you going to do? When you say random doesn't mean exemption, as far as I'm concerned.
Okay. Well, it was felt that with regard to the impact, if they happen to be doing good business practices and have audited financials that are being done, by a professional, they are complying with the rules with regard to maintaining the trust accounts. Do we need to go and look at them? I mean, we could, but isn't our time better spent doing and training people that need the education? The solo
I
practitioners,
just don't think it's
the
fair.
small firms.
I don't think it's fair.
Yeah,
I'll be truthful with you. It's not fair.
I have a concern about the expense associated with this. On the one hand, I heard you say this would carry no cost. On the other hand, I hear you say that it wouldn't be implemented until 2019 so that you could hire people and get the program up and running. I recognize those are two different concepts, cost to the lawyer in responding to the audit and cost to the State Bar of conducting and preparing to conduct the audit. Do you have estimates for the cost of each?
We do. If we look at, with regard to how much it would cost the State Bar to do and whether we have the funds.
And what's the budget on that?
And as I recall, it's about 60 to 100,000.
116,000 for annual cost. In the 2018 budget, we've already plugged in $85,000.
And do you have an estimate of what it would cost a lawyer to respond to your audit?
Well, the answer should be nothing, because all they have to do is put together what they already should have together, which is basically pull their bank account and the money, the people that they're holding the money for.
Well, but they have confidentiality issues. There's all sorts of associated concerns. I mean, the friction on the time of the lawyer involved in doing that and then hiring professionals to assist in that, if it's at all complex, is something that's a cost that the person being targeted is going to have to address. And if they're a large firm, I'm sort of sympathetic to what Brother Cherry's saying. They have an audit already done, they're in place, but some of the smaller ones don't. That's enormously disruptive and quite expensive.
Well, it shouldn't be, I don't want to differ, but it should not be expensive for the solo practitioner or the small firm, because actually that's the cost of doing business, and if they've been doing business, they should be doing it properly to begin with. What we're saying is, I don't know, it just seems to me like if we're incurring an expense, that they're incurring an expense to comply with giving us the information, it means that they weren't doing it correctly to begin with.
Well, but you're looking at $120,000 for 60 audits a year. I mean, in-house with somebody who's doing nothing, you're looking at $2,000 an audit. You can't say it costs the responding lawyer nothing. I mean, I think that's unrealistic.
Okay. Well, I think that maybe it costs them some time. Okay. Should it cost them the cost to CPA or staff? That staff person should already be accounting for trust accounts. And solo and small practice, it seems to me like I've been in business. I can't imagine being in business and not knowing what should be in my trust account and keeping a constant, keeping track of it with regard to who you're holding the money for, and you just.
But it gets complicated with some of the liens and, medical provider liens and the negotiation associated with those. I mean, there's a lot of factual overburden on some of those monies that to take a freeze frame and do it right at that moment is something somebody's going to have to drop whatever else they're doing in that law firm and respond to that, especially if it's a small firm where people multitask.
Okay.
And I'm a little concerned the rule has a provision in it existing that about costs, and there's a prevailing notion out there that it's possible some of the costs would get shifted to the targeted law firm. I don't see that in your proposal, but I don't know whether
It's
that's
not there.
contemplated at all. So the bar is going to fund the 115 to 120,000 expense?
Yes, absolutely.
And
that's
where
what
does
we
that
do.
new money come from?
We've already put it in, because we make choices, and our choices with regard to the bar is how to protect the public, and so we are taking funds that we can allocate to this concept of doing this audit.
Okay.
And without bar dues increases, there will be no bar dues increases foreseeable with regard to implementation of the random trust account audits. So the attorneys are not going to see dues increase because of the random audits.
Is this really may I?
Yes.
Is this really the best, most cost-efficient method of educating the bar about trust accounts? 60 random in a year, as opposed to using money for comprehensive education, maybe saying you can get one general credit of CLE a year for management, implementing some other education program in the first 3 years, you have to take one credit about handling funds. I mean, is this kind of piecemeal, we'll do these random audits to educate the bar? Is that really the best, most cost-efficient way to educate the bar?
Well, like I said, with regard to the CLE concept, the people that would go to those courses would be the ones that are currently complying with the rules, most likely, okay? And what we're trying to do is reach the lawyers that are solo practitioners starting out and show them how to do it right from the beginning. So it's more a one-on-one with regard to these. And also there's an educational benefit as well, because once they know that the state bar is going to be doing random trust account audits, I can assure you that those solo practitioners and stuff will want to be fully educated on how to do it so it can be done easily to their office so they can comply with the rule if they're asked.
Well, where do they get that information and that education if other practitioners can't even agree on what should be and shouldn't be in the trust account?
Well, that's a good point. I mean, we do need guidelines. And, it became really obvious to me, meeting with all these law firms, that when we went around, we talked to the law firms, we said, we're considering doing random trust account audits. We're considering malpractice insurance. We're doing the mock trial. I went and visited with these firms to do that, to tell them. And then when we talked about random trust account audits, that's when we got into these issues with regard to what should go into trust. What do we have to, in criminal law, do we have to do it? Yes. So there are a lot of outstanding questions. And I went back, and we're not unique in Nevada in that regard, because California just issued their guidelines in 2016 that they spent time on to try to have uniformity with regard to their guidelines as to what type of practices and how they can hold. They did hold in California that criminal lawyers who put in their fee agreement that they are fully earned, they are indeed fully earned. Okay, they don't have to put them into trust account. But that's a definite guideline rule in California as of 2016. And I'm not saying that education isn't important, because obviously it's obvious to me, having met with a lot of attorneys, when you talk about this issue, we do need education. It's not as simple as a lot of people think. We need to go back to the basics as to what is a trust account, how you maintain it, and what you should have in constant accounting for it. And we're talking about IOLTA trust accounts, but we're also talking about if they're holding funds in trust for their clients. And I learned something with regard to family law. The family lawyers were concerned because they hold assets of their clients that they do not want to have be discovered. Okay. Yeah. So they said, how are you going to? We don't want to do random trust accounts, because how do we handle those properties we're holding for our client during a divorce process? And I was a little taken aback, but that was their concern.
This is something you guys really want?
Do we really want the random trust account? I really want to improve the image of our profession so that we don't have attorneys who steal people's money and from the trust account. I want to educate the attorneys and deter and so that the reputation of all Nevada lawyers is in high esteem. So yes, I think it is something we really want. I want to see us take proactive measures versus waiting for them to have a grievance filed against them and have to process the grievance. Wouldn't we be better to have random trust accounts and prevent the cost of having to have additional bar counsel and additional time going through the process when they have an issue with their trust account?
If you find something in a large law firm where somebody has stolen money, is Dan going to file grievances, some type of grievance against them, like you do with the small law firms?
Absolutely.
Well, you haven't yet. I mean, we've always seen where the secretary steals for one-man practice, and we file a discipline case against them. But you can do it with the large law firms too, where somebody has stolen and the partners don't know it.
Yeah.
And you're going to do all the partners?
We can do all the partners. Well, you're asking me something. My term is almost up, but I would be
Well,
my
that's Rick.
recommendation.
Rick, what about you?
That they,
What about Stan? And I just want to tell you from my own personal experience. I had a small law firm. We all used the same accountant. We used him for years. He did our personal stuff, and he did the whole law firm. And we turned it all over to him, and then he gave us our tax returns and everything that we needed. Why should I have to be audited? Why should that type of situation have a random audit when a large law firm has a certified audit, which costs a fortune, by the way? Because my accountant told me he makes more money on certified audits than he does just strictly doing tax returns. I'm not sure if you understand what I'm saying.
No, I understand. But I think if you had that competent of an accountant, I can assure you that you have complied with the trust accounts. And they're probably in fine order, and you just turn it over to our auditor who will review it. It goes back 3 months. You would have no issue. It would be wouldn't take any time because you already have it set up properly.
How do they do an audit of a trust account without auditing the general account?
Well, you look at what's reported should be in the trust account and how much money is there and if it breaks down correctly. Yes, it's not an audit of the law firm.
So somebody handling the Las Vegas Sands case gets $200,000 up front, and they keep $100 in the general account and $100 go in the trust account. You understand what I'm asking?
Yeah, absolutely, yeah. But we need to look at both accounts. Because if they're holding it in trust, $200,000, and only $100,000 is in trust, and another $100,000 is sitting under general operating, that we would have to look at their general operating and ask them why is that $100,000 not in their trust account.
And if somebody can do that for $2,000, could they do my tax return for me too? For $2,000? They're going to look at a general account of a large law firm, maybe a national law firm where some of the money went out of state, don't forget, the national law firms, because...
Well, we're only looking at trust accounts of that national law firm in the state of Nevada. We're not interested in what's going on in Detroit or somewhere else.
I don't mean to give you a tough time, Gene, because I was on the client security fund with you, and I saw the tragedies that occurred, just like you did, and Jenny Hubeck when we were together, and Richard Scotty. We were all together, and it was real sad when these folks were out the money, and we couldn't reimburse them 100%. I mean, we would always do a percentage, and it was sad.
Yeah.
So I understand where you're coming from, and I understand it's you're doing it in good faith. I don't mean to give you a tough time. I just want to make sure it's fair.
Yeah, and I'm interested in fairness. We're interested in fairness too. I mean, we're trying to come up with a program that makes large law firms happy, small law firms happy, with regard to take into consideration the cost. But yet, the bottom line in today's world with regard to bar associations, we need to do everything we can to protect the public. And we also need to go the extra step to protect the profession, our profession, and make it honorable like we all want it to be.
Justice Hardesty?
I have a few questions, Mr. Levery. Maybe as the one person on the court who's actually conducted audits in my accounting days, one of the concerns I have is, and it just came up in this hearing, is the absence of guidelines as to what the audits are supposed to, what the trust accounts are supposed to reflect. My experience in doing audits is that you measure the conduct of the trust account against the established guidelines, and that forms the basis for compliance or non-compliance. Is the State Bar in the process of developing a set of guidelines, or have you consulted with accountants who can furnish suggested guidelines that could be incorporated? I think I'm not nixing the idea of an audit. I'm concerned about the fact that we might have the cart before the horse, because I don't know how one would conduct an audit without knowing what the standards are. I know you've heard of generally accepted accounting principles. Well, those are enacted to measure the financial performance and balance sheets and income statements of entities for audit purposes. And the same would be true here. I can see some legitimate questions being raised about how is a trust account to operate. Not all trust accounts are going to be audited for purposes of determining theft. They're going to be audited to determine whether the incoming deposits match expenses, and then other issues such as what is supposed to be deposited into a trust account or can be deposited elsewhere. I'm sorry for the long-winded question, but the absence of guidelines is a concern. I would also think, I had some other questions having to do with the sample size. I read all the survey responses, and one of the areas that was not frequent, but observed fairly often, is that the sample size is too low, that 2% is not an adequate sample size. So that raises a couple of questions. How is the sample size determined? I noticed in the moving papers it was the product of the approach taken by the IRS, but obviously their body of work is pretty substantial, so their sample size would be expected to be demonstrably different than ours. And then in the states that actually conduct audits, the 3 states that enforce the rule or 4, did they provide statistics that demonstrate the number of instances in which there were audit violations, and including referrals for discipline? Those are 3 of my primary questions.
Maybe I can take your last question first,
Sure.
so I can remember it.
I
With regard
apologize.
to other states, that information we did not request, okay? I don't know if it's available, but we should. With regard to your question with regard to guidelines, I agree that we can't do the random trust account audit started without having the guidelines. And the guidelines are what we will be working on. If you approve the random trust audit concept, we would gather people together with regard to the various areas of law, like I told the NJA we would do, and have them participate with regard to setting up what those standards are. Because we do need guidelines and standards to do a proper random trust audit, because we all need to be on the same wavelength with regard. Your third issue, what was the third point?
Well, the third question I had was dealing with the guidelines and then the referrals out and violations.
The 60.
And the sample size.
Yeah. And, the concept was how many audits can we do with our staff and our funds to do a good job? And that's where we arrived at 60. Okay. So it was based on the ability of our bar association with regard to, with our financial aspects, that we could do 60 good audits with regard to.
Well, for example, I didn't mean to interrupt you. Were you done there? For example, in the state of Washington, the information that's been provided here indicates that they undertook 80 to 100 audits.
Right.
Did they supply information as to the basis for those selections, how they established that audit size? Yeah,
How they came up
was
with
it, yeah,
80
was
on
there is no question that there is a statistically valid method for assessing the random sample size to conduct an audit. I have no doubt about that. There's 3,202 audits. That kind of matches up with, or does match up with the number of IOLTA trust accounts that we report. But I'm concerned that the sample size not be selected based upon what we can afford to audit, as opposed to whether it's a reflection of what should be audited. And we also know that of the 3,202 trust accounts, a substantial portion of those have huge dollar amounts in them. So would the sample size be driven by dollar amount as opposed to number of trust accounts? Do we benefit by auditing a trust account that has a routine running account balance of $25,000 versus trust accounts that have 10 or 11 million? That's my concern, and I would imagine that if you all selected one or two accounts that had 10 or 11, or let's take Mr. Graham's account, 19 or whatever the number is, I don't know that you can get that done even for a 3-month sample size for $2,000. That's a pretty significant undertaking. But it all depends on the guidelines. I don't know how one can design the program without knowing what are the standards under which the accounts are going to be evaluated.
I'm not disagreeing with the standards, okay, in fact, but I don't think we would get the interest of the bar to participate and develop what the standards are until we had the random trust account concept approved by the court.
Well, I think you could, Mr. Leverty, and I am not nixing the idea of an audit. I think there's a lot of good comments in here about the benefits that can be achieved. What I believe, though, everybody seemed to say over and over, even a lot of the no's, is that education and guidelines would be helpful. Well, whether we did audits or not, it would seem to me a beneficial goal of the bar to adopt the guidelines, impanel a committee to do that. We need to do it anyway.
Yeah.
And then start an educational campaign for people to be able to follow those educational standards. I could see a tremendous benefit there. And I would hope that the Board of Governors would consider that effort. I could see that being really helpful. I mean, quite frankly, from my point of view, I would think that the amount that one deposits in their trust account versus their general account is going to be guided by the fee agreement. That's the starting point. And yet, I suspect that in a lot of instances, the fee agreement doesn't even talk about that.
Good points. Okay.
So I would urge the bar to undertake the setting of guidelines with the assistance of the accountants that you're conferring with regardless. I think that's a needed effort.
Yeah.
And I'd be happy to support that in any way I could, just speaking for me.
Yeah, I would echo that. And just a straight audit of a trust account, the money's in the trust account and leaving the trust account, and there's an upfront issue of where does the money go and how is it deposited and what guidelines are you looking at to check that. That expands what you might be auditing. But I think people are entitled to self-measure against guidelines that are in place. And that's, I think there's a demand for education on that. I'm worried we're getting the cart ahead of the horse a bit. Auditing against something that we don't know what the guidelines are or what we're really truly measuring.
Could the court approve the concept of random trust audit concept subject to us presenting to the court guidelines with regard to, because our thought was to get the random trust account approved by the court, and then what we do is we develop the guidelines with regard to, so before the program started. We would be educating people that these are the guidelines and participate in the guidelines, and we would have the guidelines in place and educate before we started the program.
You know, the ABA, lately, some of the articles I've been reading talk about the flat fee rather than hourly anymore. And that gets confusing then when you talk about a flat fee, like a divorce case or a criminal case, a flat fee, as to what should even go into a trust account. Because if you take the flat fee, that means you can't take another case. You've taken that case and you can't take the other case because you can only handle so much.
Yeah.
And so that confuses me, Gene. That really confuses me as to the fact that the whole system, the legal system now, is looking at getting away from points, 0.2, 0.3, trying to bill like that.
But even on flat fees, Justice Cherry, if one doesn't earn the fee, I think our rules require that you have to refund a portion of the
Not if you're a criminal
fee.
lawyer. We already, when I was on the disciplinary committee, we were able to resolve that. The way I resolved it was have some big firm lawyers come in because the fees were not that big, the non-refundable fees. And they were used to big fees. So they thought it was a drop in the bucket that somebody got $5,000 when somebody was arrested for possession, and then the case was never filed because there was an illegal search. And the $5,000 was kept, and it was never went in a trust account.
But Justice, I understand that a lot of lawyers in Nevada believe it's fully earned, and I've had discussions with them. But there's others that believe that they pull it out as they earn it. So there is confusion, and that's why in all these areas, and in fact, your flat fee, you're right. That's what the ABA is pushing, flat fees, to help the people of moderate incomes be able to afford their attorneys. And maybe we should look at all those issues. And I'm not saying that this, like I started out saying, trust accounts are not as easy as we set forth and we all believe. It's much more complicated, and that's why we need to have uniformity in our rules.
Mr. Laverty, we're in a state where we don't have a requirement that you have to have a fee agreement, which is kind of a conversation within the conversation.
Yeah.
Probably is very good practice, but
Yeah.
it is an issue. And unless my colleagues have additional questions for you right now, I would like to find out if we have any other speakers who wish to speak and then bring you back.
Okay, thank you.
Can I ask one question?
Yes.
I'm sorry.
Yes.
There'll probably be more than one. I just feel like in some ways we're conflating two classes of people, because we've kind of said like people who catch these people who are stealing. So there's people who are stealing, and there's people who just don't understand, might not understand the rules or be inept.
Right.
The second class of people need education. And so I'm still curious about whether this is the way to educate them when we still don't even know what the standards are.
Yeah.
For the first group of people, you mentioned at the front, okay, you have 300 open cases, 75% involve money. That's 225 cases. Well, how many of those are you auditing all their financials? For the people who steal, prompt investigation resolution of a complaint about money would seem to be a more reasonable triggering mechanism for an audit than just a general audit, I
Yeah.
guess. Does that make sense?
Yeah. So if I understand what you're saying, if we know that we have a discipline issue involving safekeeping, why don't we audit those
Right.
those people?
Yeah.
Okay. And we technically have the authority for that. Yeah. I mean, to investigate those grievances. And I've also heard complaint that we have lawyers that will attempt to comply with the rules, and then the ones that are going to steal are going to wait until you audit, and then they're going to steal right away, okay, after you get completed. So they'll go back. We can't, the only thing we can do is give them the fear, and that's why we don't have a stated period. If you are audited, we don't say you get a free rein for 3 years to 5 years, because the thought was, if we can go back and do that, require that audit again if there's some suspicion that we need to go back and do it again. But, you're right. Thank you.
I don't know if we had a list, but do we have anyone else who wishes to address us as of this issue in Las Vegas? Yes, sir.
Thank you.
Come forward and please state your name.
Sure. My name is Glenn Goodman. Thank you for hearing me. I'm one of Doug Crawford's victims. and he stole about $80,000 from us. And I'm just a small business owner, and I don't see or understand why there's going to be a concern for big law firms or small firms. What is a small firm? It constitutes a big firm. Why is there a separation between the two? And, sorry, I had all these thoughts going through my head back
Just
there.
take your time, sir.
This was not on my bucket list. And I just think if an attorney is stealing, then we start the process of going through the financials, we're already too late. And in the case of, I can only speak for Crawford, is basically some type of jail term which sends the message to all the other attorneys not to do this. Because clearly there's going to be loopholes going on there. And I don't know what else to say, but thank you for your time.
Thank you, sir. Anyone else in Las Vegas who wishes to speak? Do we have anyone in Carson City who wishes to address the court as to this issue?
There's no one in Carson.
I gather that was no one in Carson.
No in Carson.
On behalf of the State Bar, Mr. Lavery, you're back up. Your closing remarks? And any additional questions from my colleagues?
I keep thinking Brian's going to speak.
We started this task force under the leadership of Brian Scott. And I'm not saying he was wrong, because I believe very much, having served on the task force, that asking for the random trust account audit under the circumstances of, of protecting the public and our profession is a good idea. An idea that is effective in 12 states. Maybe they're not currently doing the random trust accounts, but maybe they found that the process was successful. It doesn't mean that if we get our bar to do what it's supposed to do, and we do trust account audits and we find that they're all complying with the law, maybe we don't need to continue doing it. But right now, there is a need to educate and put a fear so they will go. And jail time may be effective, but it's seldom done for these thefts, because these people come to the Client Security Fund, they come to other sources to try to get remedies. So I believe, and feel strongly, that the random trust account audit is here. Guidelines, absolutely. And I didn't realize how important the guidelines were until after we started going around selling the concept of the random trust accounts and finding that there's such discrepancy with regard to how lawyers perceive their obligations with regard to various areas of the same type of law.
May I ask a couple of questions? You mentioned that under the existing rules, if there's a complaint or grievance, the bar has the authority to investigate the lawyer's accounts, including the trust accounts.
Yes.
And that's how I read the rules as well. How many times does that occur? Like somebody gets a complaint that they had an overdraft on their account, or somebody complains about their lawyer's not answering their phone calls and he thinks he has money due him. The lawyer hasn't paid him and won't answer his phone calls, whatever it is. How many times does that kind of red flag trigger a request to audit financial accounts?
Okay. Quite frankly, as I understand what's happened in the past, and I'll defer to the Bar Council, if there's a problem with regard to, we get a notice from a bank that there's insufficient funds. That comes to, is automatically reported to the State Bar. The State Bar then immediately contacts the lawyer. The lawyer comes in, demonstrates that it's a mistake or not a mistake. Do we, at that point, go in and do a financial audit? And I don't think we do we? Yeah. So
it depends on the circumstance, but we don't do it as a rule.
Yeah.
And what about a grievance with somebody like the gentleman who spoke here, and I don't know your precise circumstances, but say he had called his lawyer and said, I thought I had money coming me, or I paid you money and you haven't done anything. What's going on? And then he calls the State Bar. What happens then as far as looking into the lawyer's accounts. It would be sufficient to launch an investigation.
And I agree with you, and that's, I can give you an example of where we had those type of complaints, and basically the lawyer is in jail, but he was able to demonstrate, or he did demonstrate, that from his bank accounts, he had all the funds that he was supposed to have in trust. Okay. However, he had another area with regard to how he was acting as trustee, and it was involved with IOLTA funds where there was stuff going on. So on the one hand, he was able to demonstrate to us that he was in compliance. However, there was a whole, and probably an audit should have occurred. But before,
I'm just wondering about the balance. It's
yeah.
further to what Justice Stiglitz was saying in a sense of how do you focus this? And it seems to me the people who are having red flags, even if they're not overdraft notices on their trust account, but other types of red flags may be the ones that would be the audit trigger rather than just a random. And I understand the importance of random. I'm not diminishing it, but I'm trying to figure out what we're really doing.
Yeah, and maybe from that take, maybe what we should be doing is taking the money that we're going to be putting for a CPA to assist us in the random trust audits, put them on staff to help us do these random audits with regard to people that we have red flags for.
Yeah, they wouldn't truly be random then. They would be
random
provoked audits.
Yeah. So it would be targeted.
Yeah.
So we were trying to make it random. Yeah.
Well, how many, your chart actually put me in mind of it. No, I'll be quiet after this. I don't want to monopolize your time, but the chart of the 12 states that have this provision, like Nebraska, rules not enforced, but it says in practice the audit is usually ordered because of grievance or overdraft notice. Same thing for New Hampshire, Washington, part of an investigation. I think Mr. Craner's note also referred to a 105 investigation being a trigger rather than purely random.
Right.
I'm just wondering what the committee's thoughts on that were.
I mean, well, it already triggers. We get notification on IOLTA accounts that there's an overdraft issue, and the bar looks into those immediately.
But that's not necessarily a formal audit.
No, it's not a formal audit. What we were doing is trying to just implement. We adopted pretty much the Washington concept with regard to the random trust audits. We were using their program because they informed us that they found it effective at decreasing the amount of safekeeping issues that they had before. So that's why the random trust audit concept was being considered. That's true. No? Any other questions?
Anything else?
Thank you for your time.
We thank you. Since we could not engage either Mr. Parker or Mr. Scott to come up and say a few words, we will end our public hearing this day. We will allow any additional comment, written comment over the next 2 weeks. As I indicated, Justice Paragiri and Justice Gibbons wish to be in our caucus in terms of when we discuss this matter. So we will take this matter under submission at this time. This will close.